Okay, it's 3:10, and as you can see, David is putting his headphones back on, so we're just about ready to go, and it will be slightly shortened because Todd is unable to attend, as David mentioned earlier. So on that note, I'm going to turn it over to David to talk a little bit about some of the lessons and strategies. A recap. Go ahead, David.
Thanks, Earl. So what I'll do is I guess many of the people in this webcast were involved in our webcast on November 24th, where we had the pleasure of hosting Judge Bowman to talk about landmark tax cases and his opinion on the object and spirit of legislation. We didn't have a lot of time for follow-up or recap because we really wanted to give him the floor and use up the time dealing direct with him. So what I thought I would do with Todd, who couldn't make it, is just recap some of the lessons or some of the things that we thought are worth reiterating from that area, and perhaps because we've had a lot of interest in it, use it as a table to discuss future topics for future events. So one of the things that we talked about was, and the cases, each of the technology cases highlighted was a new, or I'd say a renewed focus on defining standard practice, both by the CRA and by the tax courts. The Northwest Hydraulics case talks about, what's knowledge available at the outset and what's standard practice. And one of the key things that we talk about here is that the CRA's position is that the researchers, because they were so skilled, they were engineers and both PhD professors, again, couldn't really face any problems because they were already at such a high level of standard practice. And again, what was important here is to benchmark what was available, what variables were not in the existing models, which they were able to do, and why understanding the interrelation of those variables was not within the existing predictive algorithms available to them at the time. One of the things that I think we want to reiterate, and it's a problem here in Canada, is really that I believe that the issues of whether something's an advancement or not is between two scientists. And both sides should be required to have evidence for their position. We'll talk about this a little further. But what happens in the United States, for example, is if an IRS reviewer or auditor wants to deny an R&D tax credit claim in the U.S. on the basis of something not advancing standard practice, they would actually be required as a scientist to provide evidence for their opinion. They can't just have an unbiased opinion and say, well, I have these letters behind my name, so I don't have to prove anything with evidence. They treat it like a real scientist, as two scientists would. That each side has its own evidence, and each defends its own evidence. So I'm gonna revisit that issue and whether that's a fair position for Canadian CRA employees to take, or whether they're not required to basically support their positions. Okay, now one of the things that they talk about in the cases too was the definition of a hypothesis, and this word keeps coming up, technological uncertainty and then the word hypothesis. I'm finding that this is getting misinterpreted almost to the point of being offensive, where tax court judges are basically saying they don't see a hypothesis because the CRA proposed that maybe there wasn't any, and again, I'm finding this from a legal standpoint, very hard to understand. They say that basically a hypothesis is a tentative assumption to an unknown problem, has a requirement of a logical plan devised to observe and resolve the hypothetical problem. And there's various definitions that we have. Now, one of the key things is that the hypothesis and key variables are kind of linked. To say there's a hypothesis, the hypothesis is generally designed or linked to saying, I've identified several variables, W, X, Y, Z, whatever we want to call them, that I think the existing models don't tell me exactly how to deal with this. And if I change some proportion of W, it could have an uplying or underlying effect on X, Y, or Z. So they've clarified that technological uncertainty is something that's in the mind of the specialist who can articulate it. So it's up to the researcher or the research team to define what the uncertainty is based on their knowledge and put it down in writing, saying this is why we think there's technological uncertainty, and here's the basis of it, based on the variables we've identified, and showing that that combination of variables is not covered in any predictive model. Now, there's different definitions, Black's English Dictionary, the court cases themselves, but one of the things I like is the Wikipedia definition of a hypothesis. That normally scientific hypotheses have the form of a mathematical model, and that a working hypothesis is basically an idea for further research. Okay? Ultimately, what that requires is we want a test matrix where we talk about what we knew, what we didn't know, and what are the variables that we're going to test further. So this brings me back to talk about when we're in court, what are the actual rules that we should be following? What are the laws, and what are the roles of the different players that might come to court? And up until recently, I assumed that the role of the expert witness was to be used as, quote, a set of prescription glasses by scientists, or by the judge, right? So an expert witness may assist the court in evaluating technical evidence and seek to persuade that research objectives did or could lead to technological advancement. At the end of the day, the expert's role is limited to providing the court with a set of prescription glasses through which technical information can be viewed and analyzed and weighed by the trial judge. So what this ultimately infers, or one can take from this, is that the judge would basically take both expert witnesses, or you would assume that they would ask both expert witnesses on each side why they feel that their position is correct, and the evidence, examine not only the basis for it, but the evidence that they bring for that. So this goes back to one of the comments that we segregated in our discussion with Judge Bowman, and that is, to what extent should CRE reviewers be willing to discuss case law if a claimant feels there's a situation that provides good evidence or a similar fact scenario that could help them out? And one of the problems, a very real problem, is that it's almost a policy of CRA reviewers not to discuss case law, or very few of them will. And they'll tell you that they're under no requirement to discuss case law or any examples, which again is an area where Judge Bowman clearly disagreed with that position. And I would say it's not in the interest of the claimant or the taxpayer either. So again, the CRA is kind of saying, well, if we're not going to discuss case law itself, in my view, that's almost a contempt. They're showing contempt for the law that they're supposed to enforce here, and they should be willing to discuss case law. And the unwillingness to do such really leads to positions, as we've shown, that are completely incongruous with case law and being enforced on a national level. Okay, to illustrate with an example of a case where I actually represented the client, and I'm not trying to gripe about the fact that my client didn't win on this one, but I'm talking about what lessons can I take away from this, both on the technology side, but also as a practitioner and other practitioners who may think about taking their client's case to court. What's involved? Is it worth it? What can I do to plan for this? So I really started to think about what would I do again differently if I were to pursue this case. So the judge talked about that there was no hypothesis here, and again, this I found almost insulting. It was inaccurate and an insulting comment to make. And one of the things that I liked about the CRA software papers, they didn't talk about the word hypothesis. They talked about a SR&ED hypothesis. That maybe the client had a hypothesis, but it wasn't benchmarked against standard practice enough or prior art in order to raise it to the level of an SR&ED hypothesis. And I think that terminology is very important in here when we're talking about cases, because in my opinion, and I'll illustrate this, the claimant provided very strong evidence of a hypothesis, and yet the judge in this case just couldn't recognize it, or couldn't see it, or chose not to see it. And again, the understanding of why that happened is critical to make future claims and to understand what are the basis of this, what can we learn from this. So the real issue here is that the client came into the court and relied on evidence of a patent on what were the problems with a particular product that they were developing. And basically what they were trying to do is to take plant sterols, which are very good for you and reduce all kinds of cholesterol, and to take an existing patent held by a company where they can put these plant sterols into 16 ounces of orange juice, which is your FDA requirement for the day, and they thought that was a lot of juice to drink, so they wanted to reduce it to 2-ounce energy shots. And the very fact of the matter was that these plant sterols are very tough, fibrous materials that don't suspend well, that need various shearing and various techniques, both to become suspended and to remain suspended in a liquid. So the patent that they looked at in Cargill talked about the incorporation of sterols into aqueous systems. It outlined various challenges due to the hydrophobic nature of the sterols. It talked about literature that described incorporating sterols into water, either by chemical or mixing, that numerous practitioners have run into problems on formulation, including cost of the chemical modifications, ineffectiveness of the products, food and safety concerns, poor stability, subsequent flocculation, and poor textural or flavor properties. The patent even illustrates some of the parameters, the combinations of materials, weights, shearing techniques that again provide the system uncertainty that the taxpayer actually experimented with in his claim. He also went on to talk about that patent and how what he was developing was different, how it used some of the shearing technology and processes, but that patent actually created a powder, and they were going to try to bypass the whole powder stage, that they were basically using different methods to emulsify it and different chemicals to make the process happen throughout it. So again, as a practitioner who didn't prepare the initial claim, but said, here's a claimant who's done 12 years of successful claims, was accepted 100% of the time, and all of a sudden 1 year they got 100% denied. And at which point they came to me and said, should we fight this or not? And generally speaking, when that happens, I'd say 60% of the time I explain to the taxpayer why they lost. But on this one, I really felt that the taxpayer got a bad break, and I still really do. I don't know what to learn from this, but I do have some lessons, and I don't know if they're the lessons that are going to encourage us to go to the tax court, but they're going to encourage us to be very careful when going to the tax court. Okay? So the judge basically said that in developing a 2-ounce beverage, the main issue the appellant had was suspending plant sterols, which are fat-based substance, in a liquid to resolve the issue. The appellant used a methodology and a technology that are well established in the food industry, namely high shear mixing, mechanical pumping, by trying to heat the product at different temperatures, and by using emulsifiers that existed in the market. So they're basically saying that, if you're combining chemicals in some fashion to create something new, that can't be SR&ED unless you've created a new chemical to create those new chemicals. So again, it becomes a bit of a nonsensical argument that I've seen at CRA level, but I'm very disturbed when I hear it reiterated at the tax court level by a tax court judge. The question is, who's going to help us or put this in check at this point? Furthermore, what was stated in the case here is that the CRA professional witness, Dr. Hassanen, stated at the time of a review that there were multiple patents related to dispersing plant sterols in different products. However, the CRA reviewer didn't bring in a single piece of evidence. We had a scientist come in and say there's lots of evidence, but they didn't bring one, not one. And yet the CRA or the judge took the word of the CRA, who had no patents, versus the claimant who actually had a patent and other types of evidence, and still provided all of the basis or credibility, again, to the CRA on what would seem amount of evidence, infinitely more evidence being provided by the taxpayer as opposed to CRA, and yet the CRA was accepted because the judge made it clear that the CRA has no requirement to provide any evidence. The evidence is solely reliant on the taxpayer themselves to provide. So again, these are things that you may not expect going to court. You may think, hey, this should be like scientists versus scientists, like in the real world, where if a scientist came in with absolutely no evidence for their opinion, they would be completely discredited. And if an IRS reviewer came in this situation, he or she would be discredited as well. So how did the client lose? What lessons did I get? How did my client come in where I thought I had a slam dunk? We have the evidence, we got patents, we've got all the prior art, and the CRA has nothing, and yet we still lost. And I think a lot of it was just on the fact that relevant evidence wasn't considered, and a lot of it was based on cross-examination, analysis of transcripts, and I would call it the pattern that I see not only on this case but other cases is on tripping up the witness on the stand, asking them what were your search terms that you used, what kind of search techniques did you use, and not realizing that this may have been 3 or 5 years earlier, and that in fact at the time this happened, Google patents and things weren't really around. They were not prevalent like today. These are new technologies that came up. So they're asking questions that really aren't fair in the time scope or don't contemplate the time scope. And they're asking them without any preparation of the witness, who usually can't recall what exact search terms they thought of 4 or 5 years ago on a question that's hit right there. And yet the answers to those questions seem to be the fundamental points that the judge is relying on to make the decision. So again, is there a fairness in this? I'm saying that you want to be very, very careful on assuming that the judge is on your side in doing these, whereas up until very recently, the judges tended to lean to the taxpayer where there was ambiguity. I would say that very recently, it's gone quite the opposite. If there's any ambiguity whatsoever, the judge will tend to side with the Canada Revenue Agency. Okay. Again, some of the big problems that I've seen on these files is that the new set of cases just are not following the law. There's a case called Life Choice where the client did clinical trials and basically got the claim denied because they didn't do experiments. There's a precedence case called Hun Metapharma where the judge was very clear. He said the wording in the Act, in 248 sub 1 of the Act, definition of SR&D is very clear. It says work done by experimentation or analysis. And the words or analysis were put there by our elected officials on purpose. It wasn't an accident. They didn't mean to say experimentation and analysis. They used the words or analysis. Excuse me. The judge in this case basically said he ignored the law, in my opinion, and said you did analysis clearly and unequivocally, but you didn't follow it up with experimentation. So again, I'm seeing that the CRA is not really respecting the Act, but they don't necessarily consider the Act. But at a tax court level, this is where you would expect the judge to respect the wording of the Act and the significance of it over CRA policy that is not law. Okay. Another case that we discussed was a case called Novalia. And this is where they're questioning the theory of the scientists. So we have an individual with a PhD in music who actually patented various windmill devices. And in the patent itself, it shows you 11 other patents cited as prior art. It shows you being cited by patents after that. And again, the client lost his case. So there's a new higher degree of scrutiny being involved where a client may have all of the right criteria, but they may say because your field is music, you can't really make advancements in a field of science. Again, I'd say that often people who study music or come up with inventions, particularly in music, they understand how waves interact and the waveforms, and these are often may correlate to things like windmills or other kind of flow products. So again, I can't comment on the specifics of this case, but it causes me concern again that maybe the courts aren't providing all the right rationale for the reasons that they're using. One of the cases that won was a company called Formadrain. And we'll say, okay, well, you know, the courts aren't being overly strict. But what I would say is this one still makes me more upset than any of the others. My question is, how did this possibly get challenged? And realize that cases like this are consistently being challenged. That these guys ended up in tax court. That basically they had a proprietary process that they owned the rights on for over 20 years, that the engineers developing it had chemical backgrounds and one with a mechanical background, so they were doing joint advancements in various fields, that they developed a brand new plastic that didn't exist in order to make the product work, which was a form or a mandrel that they could put into pipes. And then they had to, after developing a new material, they actually had to integrate this new material into the process. And they were still challenged. Now, fortunately, they won, but my question is, how many other claimants like this are being challenged, and why are they being challenged? And is there any lesson for the CRA to say, why do we keep challenging these guys? Last year, there was a case of a fellow who had over 100 patents on printing technology, who developed a new printer, and merely because he sold some of the product, his claim was challenged. And again, it won overwhelmingly, but why are these cases going to court? Is anyone at the CRA looking at these and saying, is our assessments proper, or are there any lessons to learn from any of these things? Other than how to restrict the program further, how can we expand the program to the right types of claimants? Okay. So the lesson or the implications is, how do we add depth? How do we get the judges to understand the technology? What's happening now is the judges, rather than, it seems, understanding technology, are relying solely on expert witnesses. They're saying that you had more expert witnesses here, or these witnesses had more engineering degrees or PhDs than these witnesses, so they automatically win. That makes it overly simplistic, like a game of cards where I cut the deck and my ace beats your queen, so you win. If that's the case, why do we even need to go to court or write up project descriptions? The CRA has PhDs on staff who are very articulate, so unless you have a PhD to counter them, you're going to lose on every case if the judges, again, don't consider the science, if they just consider the CRA witnesses as infallible and not requiring any evidence for any assertions that they make. Okay? So what are the other options? Do we rely solely on expert witnesses? Are there other judges within the tax court that have IP backgrounds? Or perhaps there's other judges that do patent law that could be supplemented to help in these kinds of IP rulings, to again, help the tax court judges. What my concern here is that Judge Bowman really raised the bar with his issues and his questions, his understanding of how he delved into the technology. And the cases that you look at really look at the technology about why something was eligible. And now I'm worried that perhaps he was a singular kind of genius that comes along only once every generation, and the newer current wave of judges really just aren't going to be able to step up to that plate. And maybe this generation we won't have another Judge Bowman in the next generation. So what are we going to do? Maybe finding one person with that skill set is a little bit much to ask, but maybe we can combine things. Maybe the comments from CAD had an independent review committee or arbitration committee. I'm saying, well, we've also got, a pretty good background of judges in Canada with a fair amount of patent law that have ruled on patent cases. So I've referred to one of my associates, Ben Mack, a patent attorney at Rideau Mabey, and got permission to talk about some of the recent cases on patents. And there's a lot that talk about general or common knowledge. How can we do that? So the judges that talk about these kinds of issues, I think, would also be very well trained and generally have science backgrounds that will allow them not only to talk about the law, but also the science that leads to this. So maybe we're saying as a cross-disciplinary team that the tax court judges really understand the tax court law. Maybe it's a little bit much to ask them to understand the science at the same time, but that there's other judges within the Canadian judicial system that could really help bring the whole picture together in an amenable way that helps the tax courts and the claimants. All right. So again, there's different patents or issues that were looked in on the patent level that I think could be relevant to say, hey, maybe some of these things could be relevant in determining a cross-disciplinary team of judiciary that could apply for that. So to wrap it up, some of the things or the opportunities that I'm seeing are or areas of improvement are, I think that the CRA scientists and the direction from the top, the CRA scientists, if they're real scientists, should provide evidence. They shouldn't provide opinions without evidence, because that's not how scientists deal with it. Even if the tax courts are going to accept that, I mean, as scientists, that's just not acceptable. The other evidence is evidence versus expert witnesses. Should the courts rely solely on expert witnesses, or should they be able to understand the evidence as well? Does that require the judges to have maybe some technical knowledge as well as just tax knowledge? The next things I'm going to talk about are some really interesting opportunities on my court case that it actually went 3 days, and it was very time consuming and very costly. The way that the tax court works right now, I find, is very disrespectful to the claimant. They tell you to show up on a certain day at 9 o'clock, and then they say you're going to start your case sometime between 9 and 5. The very first day we showed up, we didn't actually start our case till 3:30 in the afternoon, or 3 in the afternoon. We had less than an hour and a half, and we got virtually nothing done. So we came from different cities. The Crown Counsel came from Halifax, the judge from Ottawa. I can't imagine what the expense was to the Canadian taxpayer, but we wasted the whole day. We had to come back another day, and it happened again. And really what happens is there's a scheduling system where they know they have a certain number of cases, and they could probably schedule you, but it's really like a doctor's office where they don't respect that your time is valuable, and they just make you sit there the whole day. Rather than trying to plan things out and schedule a system where it respects both the judge's time and the Crown's time and the taxpayer's time. Again, so the scheduling system of the courts, in my view, is archaic. It needs to be improved. Secondly, we actually had to go to a third day because of these mess-ups on just scheduling and whatnot. But the third day, we actually did the entire case online, very much like this webcast. And it was fantastic. We had evidence there. It was easy to go in. And my question was, why couldn't the whole case be done this way? Why can't all of these cases be done online every time? And the taxpayer can check in when the judge is ready and give a half-hour warning. So instead of me having to sit in Hamilton Tax Court all day, the judge can say at 2:30, let's log in. She's going to be ready, or he's going to be ready, and we do the case just like we did. It was fantastic. So the tax court has the ability to do this. My question is, why don't they do this? Like, why? And what can we do to encourage the tax court to do this? Because it's really in everyone's interest. Having said that, if we can do this, what are the rules on broadcasting these cases? Because I'm of the opinion that there's a lot of information here that isn't being reported properly by the tax court, or that's relevant to it, and it just isn't making it to the decisions. So if the tax court isn't realizing relevant information or reporting it properly, what can be done? And I mean, the easiest thing to do if people are losing faith in the tax system is to make it open. In the United States, we see murder trials that are published so that people understand. They may not agree with the verdict, but at least they understand how they got there because the information is public. And again, to have SR&ED claims, if, say, a claimant wanted it, the value to the community to understanding what really happened in the process could be immeasurable. So, I mean, if these cases can be done online, and not only that, if interested parties could log in and watch, and I don't see any rules to prevent this, I think these would be strong steps in the interest of justice. Okay, Earl, and on that point, I'm going to wrap it up and welcome questions or comments.
If anyone has any questions or comments, you will see now there is another poll with respect to this. So if you could vote, so just select all the statements, a little different than the other one where you select the ones you actually agree with. I think that the court system on a whole is unfortunately not as efficient as it could be. It's not strictly the tax court itself that has the problem, but clearly it would be better for all concerned if they considered people's time a little better. So I'll just give it another few minutes if there's any questions. I see someone's typing away with a chat question. You can, if you're shy, you can send me a private question and I'm happy to read it and not disclose who it's from. I guess one of the questions is what if the judge was,
Well, yeah.
I don't know if you see that one, David, if you want to deal with that.
Yeah. So what if the judge is artificial intelligence? Actually, you know what? I'm looking forward to that because I think we would get better decisions if that were the case. But that's just my personal opinion.
I mean, my concern with dual judges is just the cost and trying to coordinate it. It takes long enough now for cases to be heard. If you have to try and get before two judges, it'd take that much longer. Yeah,
I agree. But if we have the internet and you can do it all online, and you know what? I think if the, you know, maybe you have some pre-trial meetings and stuff and really agree on the facts and issues, things can be streamlined a lot. One of the things that I learned, you know, the hard way is that you submit certain evidence to the tax court, but it actually doesn't get considered unless you print a paper copy and then resubmit it to the judge. So everything that you submit in your tax court appeal, all of the documents, I'm not sure what really happens to that. If the judge ever even really reads it, I think they have access to it, but they don't actually read it until you get to court and then you have to submit a paper copy. So again, if you don't do this, you may have valuable pieces of information that don't get considered or that you think are getting considered. Again, I'd say that on larger SR&ED cases, there's a lot of value to using a lawyer and going the general procedure. And I know it's costly, but there's definitely pitfalls to doing the informal appeal. And the tax court seems to really be tight on process and putting a lot of emphasis on cross-examination of witnesses and asking really tough questions on the stand and putting more weight on that than the actual evidence that's submitted. So again, it's tough there. You really want to go in with all the evidence and no misassumptions on fairness or leniency from the tax court based on.
Still up. Someone else is typing. That's good. Another question coming in. On that note, though, I think on 5 I'm going to end the poll. So 5, 4, 3, 2, 1, and now you should be able to see the results. I'll just read out the question that you all should be able to see in the chat. Why can't a committee or panel with reps from industry and CRA be formed to hear cases before the tax court option? This I will start to address, David, and then you can jump in, but there have been a number of individuals that have tried to suggest that we need a new format, not even, perhaps even before you get to this stage, that in fact the whole flawed CRA situation is not beneficial for claimants, that you need people that are more in tune, but clearly at least a second level after that, to the extent you continue with this from a dispute resolution standpoint. And there have been a number of people that have suggested something, but again, so far to date, CRA has not, or I guess perhaps even finance might have to legislate something to get it done. They're not interested in doing something like that. It'll be interesting to see what happens if they start listening to how much and how fast and far the claims have been going down, and if this might provoke them into doing something that industry has been crying for a while. David, do you have any comments?
No, I've heard the same thing, and CATA has talked about that for 4 or 5 years, a separate arbitration committee. I mean, actually, almost 20 years I've been hearing that idea bouncing back and forth. Then the questions are who's on it, which industries. It's a great idea, and the real sales pitch would be that you could get the decisions quickly, 30 days, 60 days. That's the kind of time frame that industry is looking for. When you get objections that sit there 15 months, 2 years, what happens is that the client starts losing interest in the whole SR&ED program. They stop doing the current year claim, and then once you fall 2 or 3 years behind, even if you're successful, it's really hard to get that machine up and running again, right? So again, once the client loses interest in the SR&ED program, it took 30 years to build this program up, and it started to deteriorate very quickly in the last couple of years. And it takes decades to build up the interest and literally minutes to lose it. So it's a concern, I think.
If people have any ideas for future topics, firstly, I would like to thank David for establishing the stakeholder, the whole website and the whole initiative from this standpoint. And no, he didn't ask me to say this. This I'm saying on my own, because I think it has been very useful and very interesting. I think it could be a lot more useful, a lot more interesting to the extent we get more people to partake and express their opinions and their ideas. So again, give you the opportunity to do it incognito. You could do through the private chat. Everybody has the ability to chat privately with any of us. And I'd like to thank all the people that did partake in this stakeholder webinar, and also like to thank, as some of you said, for the people that have presented here, because it does take a lot of time and preparation to get ready for this, and therefore look forward to having more of these, and hopefully people will come up with some ideas as to what may or may not be useful in the future. One last polling question has been putting up is that to assist with deferring the ongoing cost, would you agree to a fair membership fee? And if so, what might that be in your mind? So a few people have answered, but if some people could take some time and just give your input. Again, the more we hear from people, the better off it'll be, so that people get to hear what they're looking for. So again, I thank everybody for their participation. Just give it another minute or two, and then I'll close the polling off and share the results. It seems like there's a few people that are consistently paying attention and answering the polling questions, and we appreciate that. And if more people could take part, that'd be great. Okay, I'm going to close down the poll in 5, 4. Oh, last few people are hitting it now. 5, 4, 3, 2, 1. So you can see that the results, I guess the biggest is $50 seems to be the one. To the extent that happens down the road, never know. But thank you again all, and on that note, I'm going to sign off. And have a good weekend, everybody. Take care.
Good weekend, everybody.